Esteemed Worship, State Calls 20A/113/2023, State against Nandipha Magudumana, Presiding Judicial Officer Mr. Lange, appearing for the State, Mrs. Matoko, the court interpreter Mr. Makala, and the applicant is still legally represented by Advocate Tamendi. The matter was adjourned until today for heads of argument or the address by both parties. I must state that when we adjourned, the court pronounced that we will be starting at 11 today. At 11, just before 11, the defense indicated that they're still busy with their papers and requested for 12 o'clock, but we ended up agreeing.
Thank you, Mr. Makudumana.
Thank you.
Scott, please, Your Worship, I confirm the same submissions made by my learned colleague. Your Worship, we are ready to proceed with the address, and we have also prepared the copy of the heads of arguments for the court. Your Worship, we have also prepared a set of arguments to be given to the state, but I'm not sure if my learned colleague has got a copy for us, so that we can exchange the heads. I'm not sure if he has prepared one for us. But we're willing to exchange heads with the state. This copy belongs to the court, Your Worship.
I will provide them at the appropriate time, yes.
In that way, Your Worship, then we will not be in a position to exchange same if the state is not in a position to provide us with their heads currently. And may I proceed with your leave? God bless you. I will first start by addressing you on the issue of schedule. I remember yesterday when I addressed you, I made an undertaking that I have looked into the charge sheet, I have looked into the charges, and I am convinced that based on what is contained or allegations contained in the charge sheet, that we are appearing before you on a Schedule 5 bail application. But however, after evidence has been tendered, and after I have looked into what is contained in the charge sheet, and after the state case has been closed, I am more than convinced that we are appearing before you with actually a different schedule altogether. But before perhaps I go there, Yoshi, allow me to also make a remark about what I observed yesterday when the state was putting its case on record. The court will remember that the state read its affidavit on record, and the court will also remember that there was a stage when the prosecutor made an amendment on an affidavit. I'm making this submission because that affidavit was not an affidavit which was deposed to by the prosecutor. And in terms of the law, he was not allowed to interfere with an affidavit which was not his affidavit. That affidavit was made by a policeman. It was made under oath. Everything and anything that is contained in that affidavit does not come from prosecution. Your Worship, I believe in the experience and expertise of the Honorable Court that the court knows that an affidavit cannot be amended. It is principle of practice that affidavit can only amended through supplementary affidavit by the deponent thereof. But yesterday we had a situation where it was the other way around. So my submission in relation to that is that amounts to a procedural irregularity by the prosecutor. There's only one thing that can be done if there are errors on the affidavit. Spelling errors, those can be raised, those can be narrated to the court to say, at paragraph so and so there is a spelling error. This word, something is missing from this word. Easy as that. But what we saw yesterday, it was a substitution of a word which means something else with a word which means something more different. So I submit that conduct is not provided for in the law. It is not in accordance with the law, and it is therefore unlawful. Then I want to address you on the issue of the legal issue on the issue of schedules. Why we agreed yesterday that it's a Schedule 5. As I said to you, it's the charge sheet before you. There are 16 counts. Out of those 16 counts, what makes this matter to be a Schedule 5, looking into those charges, is only count number 3 and count number 4. The rest of other counts, they don't turn this whole matter into a Schedule 5, because those are offenses that ordinarily falls under a Schedule 1. The court knows the onus and the standard of proof if a bail applicant is facing a Schedule 5. But I need to persuade you, Your Worship, and to also show you why I am making these submissions, why I'm saying this is a Schedule 1 and not a Schedule 5. Your Worship, in doing so, I wish to refer you to count number 3. And let's look at what count number 3 states. Count number 3 states that on about 14th of April 2022 in Bloemfontein, District Mangaung, in furtherance of a common purpose, unlawfully and intentionally directly gave or agreed or offered to give to any other person, to wit Tebo or James Dipolo, being accused number 3, any gratification to wit an offer of 2.5 million and paid him 40,000 rand. Let's put a full stop there. Your Worship, it was on the basis of the amount which I saw of 2.5 million that I said I can accept that a charge of corruption where the amount is more than 500,000, therefore automatically it will qualify to be a Schedule 5. It was only on that basis. But Your Worship, remember, a charge sheet alone without any support of any evidence whatsoever is not evidence. There must be evidence on record to convince the court that the court is sitting with a Schedule 5 offense. where is the evidence from the side of the state to show that count number 3 is actually a Schedule 5 offense? Then allow me to refer you to Exhibit J. Exhibit J is the opposing affidavit by the state. Unfortunately, is not numbered. All the pages are not numbered, and I'm therefore unable to direct your attention to a specific page number because all of them are not numbered. But allow me, Your Worship, to refer you to a paragraph which starts with N. Paragraph N. If you count the pages, I think it will be at page number 10. Is Your Worship there? Then Your Worship, it's paragraph N. It's on top of that page, and it reads as follows: that the applicant is facing serious charges. The state has an overwhelming case against the applicant, and this is important, and is linked to the crime as follows. In other words, here the state is saying, this is how we are linking the applicant with all these charges as stipulated on this page. And now the state went on to state for count to count as to how the applicant is linked. Let us, Your Worship, on the same page, look at count number 3. This is the evidence upon which the state says it is linking the applicant with count number 3. In other words, this is the evidence that the state says, as a result of this evidence, we have an overwhelming case against applicant before you. But let's read what the state is actually saying and what the state is having in order to prove count number 3. The state is saying the applicant and her co-accused acted in furtherance of a common purpose. Their aim was that Bester must escape. The objective evidence of bank statements shows that the applicant was also on occasions a source who provided the money to accused number 1 for distribution to their co-accused. So far, it has been established that applicant paid 85,000 rand to accused number 1. Full stop. This is what the state is saying is overwhelming evidence. And Your Worship, let's focus on count number 3. Let's look who is alleged to be the recipient of the alleged gratification in charge number 3. On the charge sheet, it is alleged to be accused number 3, Tebuho James Dipolo, is alleged to be the alleged recipient of the so-called a gratification. But look at the evidence which the state intends proving the allegations in count number 3. It talks of somebody different altogether. It talks of accused number 1. The charge sheet is in front of you, Your Worship. The name of accused number 1 is not Tebo or James Dipolo. It's somebody different. The charge sheet talks of 40,000 rand, but the evidence talks of 85,000 rand. But let's pause there and look at the law, what the law says with regard to a Schedule 5. There's a Schedule 5 on charges of corruption encapsulate 3 legs. Number 1, it's any offense of corruption referred to in Chapter 2 of the Prevention and Combating of Corrupt Activities Act of 2004. Number 1, involving an amount of more than 500,000 rand. If you look into the evidence which the state says proves count number 3, do we see anything or any allegations with regard to amount of 2.5 million? The answer is a big no. Colonel Flyman, who provided evidence through this affidavit, is silent about an amount of 2.5 million. Is silent. Only the charge sheet speaks about 2.5 million. Where is 2.5 million coming from? Why is the state bringing allegations on a charge sheet which cannot be supported by evidence? Because if you read the affidavit of Colonel Flyman, there's no evidence to support the allegations in the charge sheet. Why are they saying it's a Schedule 5? But let's pause it there and go further and look at other legs of corruption. Secondly, a corruption involving an amount of more than 100,000 will fall under Schedule 5 if it is alleged that the offense was committed by a person, group of persons, a syndicate or any enterprise acting in the execution or furtherance of a common purpose or conspiracy. That is the second leg. It speaks of 100,000 rand. Do we have evidence through the evidence of Colonel Flyman of any figure of 100,000? There's none. But yet the state is saying it's having an overwhelming case. Where is the overwhelming case? The state was actually trying to decorate charges in order to make it difficult for the applicant to be granted bail. It is clear from these charges and from the evidence of Colonel Flyman. It's clear. There's no evidence, number 1, of 2.5 million, number 2, of any amount of 100,000. There is none. But let's look at the third leg of what constitutes a Schedule 5 in cases of corruption. The third leg is if it is alleged that the offense was committed by any law enforcement officer, 1, involving an amount of more than 10,000 rand or a member of a group of persons or whatever. But even there, it does not feature. The question now, Your Worship, is what makes count number 3 to be a Schedule 5? What evidence are we having on record to show that the state has shown that indeed it has got an overwhelming case as it alleges? But like I said in my earlier submissions, the state is not only relying on that. It's not only relying on count number 3 to say that the applicant is facing a Schedule 5. It's not only relying on that. It is also relying on count number 4. Your Worship has got privilege of having a charge sheet before you. And I invite you, Your Worship, to look at annexure in relation to count number 4 and tell me if the names of the applicant appears there. There are people who are charged there in relation to count number 4. But the name of the applicant is not there. Applicant before you, Your Worship, is not charged with count number 4. And if you look at the charge sheet, let's look who is charged there in relation to count number 4. You have accused 1, you, accused 3, and accused 7. Applicant before you is accused number 4. is not charged with count number 4. So the question then Your Worship, is what schedule are we here with? Is there evidence before you upon which you are convinced, or which at least try to put the applicant closer to any of these charges? There's none. Your Worship, if you look into the affidavit of the state, the first 5 pages, it's a very good and nice story about summary of facts. It's a summary of facts. For 5 pages, summary of facts, which does not link the applicant with any offense whatsoever in relation to the counts before you. So I submit, Your Worship, that this is not a Schedule 5, it's a Schedule 1 offense. And therefore the onus of proof is not on the applicant, but it is on the state. But my problem does not only end there with the state, Your Worship. If you look at the charge sheet before you, how many counts are there? 16 counts. Look at Exhibit J, the affidavit of Colonel Flyman. How many counts are accounted for in that affidavit, where they say they have overwhelming evidence? How many? Captain Flyman could only account with regard to evidence to up to count number 11. If you read Exhibit J, where is the evidence that proves count 12, count 13, count 14, count 15, count 16? There's nothing. And yet the state is saying we have overwhelming evidence. I intend, therefore, moving forward, to address you, as much as it was not my intention to do so, but because here we have a situation where all those charges, which appears to be so serious to the extent that the evidence is overwhelming, but I intend, therefore, to go at least through every of the charges. I don't want to bore you with regard to count 1 and count 2. As we indicated in our affidavit, we will, at an appropriate stage, come up with our defense. We reserved our rights in terms of disclosing our defense. I've already addressed you in relation to count 3 and count 4. I will move to count 5. And in moving to count 5, Your Worship, I will look at what the charge says vis-a-vis the evidence of Colonel Flyman. Count 5 relates to a fraud which is allegedly which took place in the district of Mangaung where there are allegations that there was common purpose, all those people that are written there. And then you go to evidence of Colonel Flyman on the same page under paragraph N, and look at what evidence he says the allegations made by the state to prove count number 5. He says he has got direct evidence or witnesses who confirm that the applicant and the accused 9 claimed the then unidentified body. The objective evidence is that the applicant's fingerprints was on the claim form. Fingerprints on the claim form. In brackets, it is required that the person who claims such a body must give his or her fingerprints. This is the only thing, according to the state, which they could say that they have in relation to this count. Number one, they are not saying there was a finger on a lifted on a form, which fingerprint we meshed with the fingerprint of the applicant and found results which are positive. They are not saying that. Your Worship, you are a court of record. The record before you will reflect. But before I say that, I also need to mention that there was no any identification parade whatsoever that was held, wherein the applicant had to be identified. But why I said you are a court of record, the court will remember, even if Your Worship was not the presiding officer on the second appearance of the applicant, that the court ordered her to expose her face. The court did not do that meromotu, but it did that as a result of the remarks made by the state to say, Your Worship, please order the applicant to remove her mask. And the court did not only stop there, that she must only remove the mask. Even though she had covered her head, she was also ordered to remove everything, to expose her identity. No identification parade held. She says in her affidavit that I do not know any of the witnesses. Now, identities exposed, there are TVs, cameras around there. Now the state comes today and say, no, we have got eyewitnesses. Because the state is now arguing that we've got an overwhelming case, which at the end of the day, they're going to argue that they've got a strong case and therefore applicant is not an appropriate candidate to be admitted to bail. I am saying that cannot be the case. I move to count number 6. I'm forced to go this way because there's evidence which the state handed in which accounts for each and every of the charges. And the state further says it has got overwhelming evidence against the applicant. On the basis of that, she must be denied to be admitted to bail. I can't read. Count number 6 is there on record. It will be waste of time for me to read it. But if you look at evidence provided by Colonel in relation to count number 6, it's just a sentence and a half, which he says it is evidence which proves count number 6. In there he also see count 8 to 12. Really, can we say what is written by Colonel in relation to count number 6 proves the allegations or shows that the state has got a... Colonel is not saying, instead he gives just one sentence where he says It is his evidence that to facilitate the escape of Bester, the unidentified body and Bester's cell were set alight. See also count 8 to 12. This is the evidence. If you read this affidavit which was handed over to you by the state, it is the evidence upon which the state is relying on to say they've got evidence in relation to count number 6. I submit that they have got no evidence. If your worship has got to rely on this affidavit, there's no evidence. I move to count number 7. Count number 7. I look at the charges. Your Worship, as I indicated, with regard to our defense, we reserve our rights to disclose our defense. Can I take instructions? Your Worship, allow me to move to count number 8. The charge sheet is in front of you, Your Worship. You can see what is contained in charge number 8. It is alleged that the applicant unlawfully and intentionally and in furtherance of a common purpose assisted an inmate Thabo Bester to escape from G4S Correctional Center. These are allegations. Look at the evidence on the affidavit which is intended to prove this allegation. Half a sentence, half a line of a sentence that says, see the contents of evidence, count 7. If you read that, evidence in relation to count number 7 does not even attempt coming closer to these allegations in the charge sheet. Does not. Because if you read count number 7, if you read, in fact, evidence on count number 7, I will read it for the record. It says, there are direct evidence / eyewitnesses that the applicant arranged a fake funeral, that the applicant fraudulently claimed the body, in brackets count 5, as that of Bester. When claiming this body, she also made a false statement to the police. Applicant introduced herself as Dr. Nandipha when she claimed the body of Bester. This, what I've just read, is intended to prove allegations in count number 8. And I submit, Your Worship, that what is contained there has got nothing to do with allegations which are contained in charge count number 8. Those are two different things. If I'm wrong, from this affidavit of Flyman, Colonel Flyman, I will be happy to be directed at anything in this affidavit that proves these charges. I will be happy. Let's go to count number 9. What the state alleges in the charge sheet is not what the policeman comes and states in the affidavit. The state, count number 9, does not charge the applicant before you. But there comes Colonel Flyman with an affidavit, and he says he has got evidence in relation to count number 9. Applicant is not charged. If you read and look at that annexure in relation to count number 9, only accused number 5 is the accused. But let's look into what Colonel is saying, that how he is linking the applicant with count number 9. This is what he said. The applicant rented a house in Sandton where she and Bester stayed. There is a lease agreement and the files that were seized on this premises after the arrest. The applicant and Bester were seen by members of the public in each other's company. They also communicated further committed further fraud after the escape. There was even security to protect them at this house. Is this intended to prove the allegations in count number 9? Can never be. But even besides that, applicant is not charged with regard to count number 9. Count number 10, it becomes a comedy on its own, Your Worship. If one looks into the allegations in the charge sheet, it talks of a commission of a crime which took place in certain areas or places. But what's more